Welcome to this presentation about shared parenting law, policy and practice over the past decade in Denmark. My name is Jesper Lose. Looking first at the positives in the last decade, we have to start off with the 2007 reform. Shared parenting is the norm in the Danish society, and by the reform, shared parenting legal custody became the norm by law. Spousal support in general declined, and there was reasonable child support cost. In 2012, shared parenting was the basic assumption by law. Children's rights to both parents was emphasized, and children transportation to and from the parents was the responsibility of both parents. In 2015, we saw the harassment package with automatic revisitation, holidays, and meeting obligations to prevent parental alienation. In 2019, we created a new family court system with green, yellow, and red visitation in children cases. Double residence became possible by law in agreement by parents, and family mediation and children unit supported the family court system. Psychological violence and including parental alienation was stated by law. In 2022, public information for both parents became the law, and child allowance was divided 50-50 also by law. In 2023, we have seen parental leave divided 50-50 by law, with at least 3 months earmarked parental leave per parent. Family violence and crisis center also has become gender equal by law. So in 2024, equal parenting time 50-50 is the fastest growing and the most used visitation scheme in the Danish society. So what we have in Denmark is a family court system that looks like this. We have the green, yellow, and red cases. The family courthouse initially handled all the cases with their children's unit looking after the children, screening the cases, and creating mediation and parental courses for collaboration and conflict mediation. If the case is severe, then it will be brought over to the higher court, or to the family court, and then to higher courts. The key challenge is still in the system, the family law, which is not gender equal. We have a challenge with culture where managers and caseworkers often are women, and there's definitely a women culture in the family court system. There's a lack of leadership where gender equality in the culture and how the case is handled is simply not there. And there's no consequences still for misusing the system, providing misinformation and creating situation for children and parents with parental alienation. So we do still have challenges in the Danish family court system, although we are definitely on the right track. Looking at the Council of Europe Resolution 2079 from 2015 on gender equality and the role of fathers, you could say that we, on a number of the 10 different aspects or guidelines for national law, are definitely ahead in Denmark compared to other countries also. Mainly, we have ensured that parents have equal rights to the same information. It's necessary to take the access rights are fully enforced. We encourage mediation, and the parental leave is divided 50-50 between the parents. Also, on respect of the right of the child, we actually right now on what we call 120% level, because children are heard and are heard several times, and maybe too much in the system right now. This to protect the children, but still it is the responsibility of adults, of the parents, to make sure that all children are looked after and have peace, quiet, and of course love and care. But definitely we are on the right track, even though we still do have challenges in the Danish family court system. To make sure that do see the fully enforced of the Council of Europe resolution, we have currently created a human rights case against the Danish government to make sure that shared parenting law is the basic assumption in all aspects of the family law. The human rights case right now going on in the court system is related to double residence and equal parenting, not only being the norm in society, but also being the basic assumption by law. We claim removal of residential and non-residential parents in a society where 50% of children under 18 years old does not live with their parents. You are not allowed by a government to divide parents into a residential and non-residential parent that has very different legal status. Welfare benefits should be based on actual needs and not the residential parents, creating a lot of conflict situations. Parental leave is almost there, divided by 50-50 with 3 months of earmark to each parent, but still, if you're living in a two-home family, you cannot be sure that you can actually use that right. So parental leave has to be the law in all family forms. And then on the information aspect for parents, we currently see the challenge within banks, insurance companies, and research institutions that still often does not involve both parents. So you could see, you could state that we are still living in a shared parenting world with single parenting law. If you want to know more about the Danish family system and analysis, we made the human rights case. A good way to start is to get the brief little book Fathers, which is available on Amazon.com. You can here look through the 12 different themes and the 366 items that we have analyzed related to shared parenting reforms in Denmark towards family law. You will also there find the basic principles for a shared parenting law based on 3 main guidelines and 10 different specific tasks on how you can create a shared parenting law. My Facebook and LinkedIn links is available on this page, and you're of course welcome to follow the law reforms in Denmark. Thank you very much.